Ladies and gentlemen, welcome to the third and last day of the CyCon conference. I'm Henrik Beckvart.
And I am Liina Lumiste. Hopefully, the last day will come out as interesting as the previous ones. Of course, you can contribute to that by posting your questions through the chat function and, of course, by sharing your thoughts in social media by using the hashtag CyCon2021.
But not to keep you any longer from the thought-provoking discussions, we shall give the floor to our first keynote speaker of the day, Associate Professor in International Law at the University of Grenoble, Dr. Karine Bannelier-Christakis, who will be addressing the topic of unilateral cyber actions by governments. Please, Karine, the floor is yours.
Thank you very much and good afternoon to everybody. And let's start with this presentation. On November 1946, the British Royal Navy undermined clearance operations in the Corfu Channel in reaction to the strikes of two of its destroyers by floating mines. This operation took place in Albanian territorial waters without Albania's permission. These events led to the famous Corfu Channel case. During the hearings at the ICJ, Operation Retail was supported by the UK as an exercise of limited right of self-help. However, in its landmark judgment of 1949, the ICJ refused to accept the defense of self-help or self-protection and declared that the action of the British Navy constituted a violation of Albanian sovereignty while maintaining that Albania was liable for the presence of the mines. 70 years on, in cyberspace, floating mines have become self-replicating worms, and malicious web shells and zombie botnets are circulating worldwide. In cyberspace, IT systems are today being struck by ransomware, and operations are being launched by states' law enforcement agencies. Using their law enforcement agencies and judicial authorizations mechanisms, some states have decided to act forcefully and to undertake cyber actions in order to neutralize malicious servers, dismantle botnets, patch vulnerabilities, and clean up infected computers. These operations can have a purely national scope, but they can also have an important international dimension, whether by directly targeting botnets and zombie computers located worldwide on other states' territories, or by impacting systems located on the territory of other states. For states that are undertaking these operations, such operations are necessary and legitimate. They close vulnerabilities, reduce cyber risk, and help the victims. However, this operation raises important questions. Are states in a position to sweep the web? Do they have the technical skills to do this properly without causing collateral damage? Do they have a right to act? And if so, what are the limits of these activities? Could sweeping or patching operations constitute violation of international law? And if so, what kind of violations? Last but not least, can states invoke the right of help, the right of self-protection, or right of active cyber defense when doing so? If these operations are expanded without being carefully framed, there will become new cyber issues and new grounds for tension between states in cyberspace. So the objective of this presentation is to share some thought on these issues on the basis on two cases, namely the Retadop case in France and the Hack-to-Patch case in the United States. So next slide, please. So let's start with a brief review of the two cases. First, Retadop. In 2019, the French Cybercrime Fighting Center, which is a department of a law enforcement agency similar to the police, announced that it had, in cooperation with Avast, neutralized a malicious server which was at the head of a gigantic botnet infected by a worm called Revolved. This botnet, which involved at the time for more than 800,000 computers, was used for nefarious activities such as the theft of hospital data, the use of ransomware, or the mining of the cryptocurrency Monero. And the command and control infrastructure was mostly located in France. After obtaining prosecutors' authorization, the French Cybercrime Fighting Center, in cooperation with Avast, dismantled the malicious command and control located in France, but it also disinfected Retadop's victims located in over 140 countries. To achieve this, next slide, please. To achieve this, it replaced the malicious server with a disinfection server, which was designed to respond to an incoming bot request with a specific response that caused connected pieces of the malware to self-destruct. The operation thus remotely deactivated the virus in computers around the world. Some months ago, in the Hack to Patch case, the US DOJ announced that the FBI had removed malicious web shells from hundreds of computers in the United States. Authorized by a warrant issued by a judge, the FBI removed the malicious web shells by issuing a command through the web shells to the server, which was designed to cause the server to delete only the web shell. These two cases share several similarities. The operations were conducted on the basis of a warrant issued by a judge. They were conducted on the basis of a public-private partnership. Part of them involved patching computers, and they were non-consensual. It was done secretly without the consent of the owner of the systems, and in the case of France, without notifying or implicating states where those computers were located. The main differences between these two cases seems to be the geographic scope of the operations. In the Hack to Patch case, the DOJ declared that the patching operation was only conducted in relation to computers located in the US. Conversely, in the Retadop case, the deactivation operation was conducted in relation to computers located all over the world. A second difference could lie in the technical side of these operations, but we do not, in fact, have enough technical information to precisely assess these differences, if any exist. However, what is, I think, important to note here is that the French Cybercrime Fighting Center underlined that the operation was conducted without intruding into the infected computers. With the US Hack to Patch case, there is less detail about the operation. It is therefore difficult to assess precisely the degree of intrusion into the targeted system. As we will see, these differences could have legal implications, in particular at the international level. But before legal analysis, it is interesting to note that these two operations were greeted by many observers, while others, fewer in number maybe, criticized this action, arguing that they were dangerous. Legal considerations. Very few states have addressed the issue of the legal framework that should be followed with regard to the law enforcement activities described in this presentation. Nevertheless, some states have put forward their position on the principle of sovereignty and the prohibition of intervention in cyberspace. Based on these positions, a legal analysis of law enforcement activities can be conducted taking into account the geographical scope of the activity, whether it is deployed in the territory of the states which undertakes the operation, or whether it is deployed or has effects on the territory of other states. With regard to the internal dimension of law enforcement operations, two main questions should be asked in relation to the principle of sovereignty. First, can states act? The answer is yes. All states agree that sovereignty applies in cyberspace, and it is generally accepted that law enforcement forms part of a state's means of exercising its sovereignty. But states can only act within the limit of their obligation under international law. In this regard, it is important to ensure that patching operations do not infringe upon the right to privacy and protection of personal data, or if an infringement does occur, certain conditions such as necessity and proportionality should be respected. Second, must states act? It is traditionally accepted that sovereignty implies obligation, and especially the obligation of state not to allow knowingly its territory to be used for act contrary to the rights of other states. This is the famous due diligence principle. But what can this principle tell us about law enforcement cases? In the Recadoc case, we have a malicious server which is located in France, which causes damages through the world. We also have French authorities who know about it and who think that they have the technical means to neutralize it. In this case, France could maybe say that it acted diligently. But did France have an obligation to act? Might one suggest that France breached its due diligence obligation in the case she had not undertaken the cleaning activities? I think that the answer is complex because diligence is, as we all know, an obligation of conduct, not of result. And its violation depends not only on the capacity of the states, but also on the damage inflicted on third states. And even if one claims that France had an obligation to neutralize the malicious server on its territory, this does not mean that it also had an obligation to undertake the cleaning operations. In the Recadoc case, the operation had notable extraterritorial effect, while the FBI's operation was presented as only targeting systems located on US territory. However, one might raise the question about the implications of such an operation if it had had collateral effects abroad. So the question is, to what extent could this operation be considered illegal interventions or at least violations of state sovereignty? With regard to illegal interventions, the answer is undoubtedly no. Indeed, to qualify as a wrongful intervention, the operation must meet two cumulative criteria. Firstly, that it interferes with the domain réservé of a foreign state, and secondly, that it involves coercion. It appears here difficult, I think, to assimilate these infection operations into acts of coercion against foreign states. It is true that the criterion of interference appears more questionable. However, since the criterion of coercion seems to be absent, I will not discuss this question here, but I will address this issue later in relation to the question of the violation of sovereignty. With regard to the violation of sovereignty, the answer is probably more nuanced. When we analyze the position of states regarding violation of sovereignty in cyberspace, three criteria seems to command attention. First, infringement upon the target state's territorial integrity, and it seems here that states don't always regard a non-consensual intrusion into cyber infrastructures as a violation of state sovereignty. But what is important to note is that in our cases, the available facts do not seem to indicate that there was an intrusion on the territory of another state. Second, for many states, the principle of sovereignty prohibits interference by a state in the inherently governmental function of another state. What constitutes inherently governmental function is, of course, a matter of debate, but it seems reasonable to consider that states' law enforcement agencies exercise inherently governmental action when exercising investigative powers. However, patching vulnerabilities, neutralizing worms, or disinfecting zombie computers does not seem to constitute the exercising of investigative powers, and it is therefore difficult to equate it to an usurpation of governmental function. Effect. In the retarded case, it is undisputable that the action had effect on the territory of third states. But to our knowledge, the effects were positive. No damage occurred. On the contrary, the worm was neutralized on hundreds of thousands of computers. In the hard-to-patch case, on the basis of the non-elements, it does not appear that the API's action has direct effects on the territory of third states. But either way, it is very likely that the retarded operation is not unique, or at least will not remain unique for long. It is therefore necessary to think about the effect of law enforcement operation in the cyberspace. While time is running, I just ask here a few questions. First, what is the nature of the effects? Do they have to be physical, or should we also include non-physical effects? Second, do the effects have to be negative? Third, if yes, what is the threshold of the damage? Does the damage have to be significant? Should we only take into account the expected effects or also the unexpected effects? Should we only take into account the direct effects or also the collateral effects? Many other questions could arise, but if I want to take collect some questions, I will here conclude. Conclusion. So, no violation of international law, no problem. That is the question. As we have seen, it is difficult to qualify these operations as violations of international law. This is also confirmed by the fact that no state filed a protest in respect with retarded or the hard-to-patch case, which is, I think, extremely interesting to underline. This does not mean, however, that all these operations are acceptable ipso facto, and that we should not try to frame them. In some cases, there could be a violation of third states' law prohibiting unauthorized access to IT systems. So I would like to submit two proposals. First, in many cases, these operations are legitimate and constitute an answer to a strong need. In this respect, it could be interesting turning around the notion of self-help, self-protection, or active cyber defense to determine when and how law enforcement agencies can engage in such operations. Second, when law enforcement agencies engage in such cleansing operation, they must act responsibly, and it would be interesting to establish a series of criteria for responsible behavior as well as necessary safeguards. Indeed, if we don't do so, there is a clear danger that some states might use the cleansing operation or hard-to-patch arguments as a pretext in order to undertake malicious activities in the territories of third states in violation of their law prohibiting unauthorized access to IT systems. Thank you very much for your attention.
Well, thank you, Dr. Bannelier-Christakis, for this interesting keynote speech, indicating some highly important legal and policy considerations. Like before, let's open up the floor to any questions from the audience.
Yes, and thank you also on my behalf. And we have a couple of questions already from the audience. And first would address actually the question of due diligence that you also addressed in your speech already. The question starts with the first part is that would you argue that France exercised the due diligence in the Red operation, which I think you also elaborated on, but the question actually carries on that would the affected states have had a response available under international law in case they would not agree with France's course of action?
Well, I think it depends on if they are able to show that France make a violation of international law. And from my point of view, it was not the case. So if states can't show that France make a violation of international law, their toolbox in order to react to France action is much more limited. Of course, they can take action, they can make protestation, but they didn't do that, frankly speaking, to my knowledge. They can, of course, act by taking other measures, but outside, the scope of countermeasures. So, of course, they can make protestations, they can act with retortion measures, they can even adopt a cyber sanction, but at each time, they can't adopt countermeasures, which are a reaction against a violation of international law. Is it
yes, thank
yes?
you. Thank you.
Thank you, Karine. And we have a second question from the audience. In your opinion, would the USA be liable for transboundary harm had the hack-to-patch operation affected systems abroad?
To my knowledge, and with the element I have for the time being, the US hack-to-patch operation was located only on the US territory and didn't make any damage either in the US territory and, of course, has no effect abroad. But for the time being, and with the element I know for the time being, this is the answer.
Thank you so much.
Yeah, just a generic question, perhaps as a last one. Just your opinion on how does these operations go together with the French approach to sovereignty, which it published now 2 years ago already. How do you see these two things go together?
Well, I think it's interesting because, as you maybe know, France has an important development on what is sovereignty in the cyberspace. And one aspect of sovereignty is, of course, exercising due diligence. And this is France. France exercises sovereignty over information system located on its territory, and in compliance with due diligence requirements, it ensures that its territory is not used for internationally wrongful acts using ICTs. This is the first part. A second part concerns French approach concerning breaches of sovereignty. And here we can effectively think about France, what France said about that breaches of sovereignty could occur when effects are made on foreign countries. And so we can turn around. I don't think that the approach of France was to say that every effects are breaching state sovereignty, but maybe we need to develop this aspect in order to know exactly what France means on this aspect.
Mm-hmm. Thank you, Karine, for these answers and your excellent speech. I think this discussion demonstrates really well that there are still many nuances, I dare say, to be worked out in international law and states' behavior and the possibilities that states actually, what states could actually do. Perhaps this could be also something that we are able to address in the Tallinn Manual 3.
Yes.